Of the course of the last week is a small but illustrative fraction of the evidence investigators have accumulated that proves defendant Burke is guilty.
What was presented by our office over the course of the last week is a small but illustrative fraction of the evidence investigators have accumulated that proves defendant Burke is guilty beyond a reasonable doubt of the brutal murder of Celeste Rivas Hernandez. That is the voice of Los Angeles District Attorney Nathan Hawkman, standing before cameras on July 28, 2025, moments after a judge ruled there was enough evidence to send David Anthony Burke to trial for first-degree murder with special circumstances. 7 words in that statement carry the entire weight of this case, small but illustrative fraction of the evidence. Now picture a prosecutor's evidence table, meticulously arranged photographs, timelines, DNA reports, a blue inflatable pool, a missing chainsaw, and then visualize a single hole punch driven through the center of every single exhibit. That hole is the 20-minute window inside a house on Dhini Place where no camera rolled, no eyewitness watched, and no murder weapon has ever been recovered. Everything the state has built radiates outward from that void, and everything the defense will try to do is pull the jury into it. Before we go deeper into what the documents actually show, make sure you're subscribed to Endless Cryme, because we don't just cover the story, we follow the evidence.
And that is going to be key, because the defense highlighted some arguably significant holes in the prosecution's case against singer David for the alleged murder of 14-year-old Celeste Rivas Hernandez. So what we want to do is talk about what those gaps may be and what the prosecution may do.
The preliminary hearing laid out a roadmap of the prosecution's case, but it also exposed 7 structural gaps that could determine whether David Burke spends the rest of his life in a prison cell or walks free. These are not technicalities. They are the kind of absences that reasonable doubt feeds on. The first gap is the most fundamental. No one can say with forensic certainty what happened inside that residence.
Detective Farrell confirms that there was no surveillance video of Celeste or David at the residence that night. There was no presentation of witnesses seeing Celeste enter that home on Dhini Place. And while the prosecution asserts that David arranged for an Uber to pick Celeste up that night to take her to his place, and reportedly there was a text conversation about that, including texts about the address, the Uber's arrival, the gate door being unlocked, apparently the Uber driver could not definitively say that he dropped Celeste off at this house. Detective Farrell testified that nobody saw Celeste get out of the Uber that night. No one testified, as of yet, that they saw the killing or watched Celeste die. There were no witnesses called regarding that specific 20-minute or so period of time, that window at night when prosecutors believe Celeste was murdered after allegedly arriving at David's place. Now, what could the prosecution do? They could couple the text message exchange between Celeste and David with location data on the phone, potentially map it to the purchase of items from David afterwards, or allegedly from David afterwards, and use the allegation that there is no more activity from Celeste's phone to put out a timeline of when she allegedly arrived and when she was allegedly killed. That's how they even get to that 20-minute window. And yes, cases can be brought and won on circumstantial evidence alone. You and I both know that. You don't always need direct evidence like surveillance footage or an eyewitness.
Detective Corey Fell of the LAP confirmed under oath that there is no surveillance video of Celeste entering the home, no witness who saw her get out of the Uber, and no testimony placing eyes on the killing itself. The prosecution points to text messages arranging the ride, location data, and the sudden digital silence from Celeste's phone after arrival. They argue those facts bracket a murder, but the bracket contains only inference, not observation. The state's own deputy medical examiner, Dr. Grant Ho, testified that he cannot pinpoint the exact date of Celeste's death based on the autopsy. Advanced decomposition collapsed the timeline into weeks, not hours. If the defense can convince a single juror that she might have died after April 23, 2025, after David allegedly sent a dozen follow-up texts, after the car trips to Santa Barbara, after the album release, the chronological foundation cracks. The missing blade cuts both ways. The second gap sits directly on the autopsy table.
No murder weapon was ever recovered. And to give you an idea of what I mean, you go to the cross-examination of Dr. Grant Ho, this deputy medical examiner that I mentioned. This is when the defense was questioning him, because the defense asked if advanced decomposition, which we have in this case, can affect the accuracy of drug results in toxicology testing. The witness says potentially. The defense asked if it's helpful to know whether a person has a mental health history, whether they're suicidal, whether they're a habitual drug user while preparing an autopsy report. The witness says potentially. Dr. Ho didn't apparently speak with relatives about these characteristics or potential characteristics. And the defense, as far as we could see, seemed to insinuate on cross-examination, is it possible that Celeste may have stabbed herself, that she may have done something to herself? You know, defense attorney Marilyn Benarski had Dr. Ho establish that he cannot rule out that the 2 penetrating wounds, which he claimed were the cause of death, occurred within seconds of each other. Quote, you cannot determine whether Miss Hernandez was holding the knife that caused the 2 wounds, correct? Correct. You can't rule that out, right? So that is a consideration, but we would expect to find hesitation marks. And then he was asked, is it fair to say that you don't know the circumstances under which these wounds occurred? And he replied, correct. Assuming, of course, it's a knife, right? We don't have the murder weapon. That leaves room for reasonable doubt. That leaves room for the defense to explore. And we have to imagine the defense could bring in their own pathologist to testify to maybe a different cause of death.
Dr. Ho stated that Celeste suffered 2 penetrating wounds to the torso, injuries he classified as the cause of death. But on cross-examination, he conceded he cannot determine who was holding the instrument. He cannot rule out self-infliction. He acknowledged that knowing a decedent's mental health history, suicidal ideation, or habitual drug use would be relevant context, and he had spoken to none of her relatives about those subjects. The defense pushed this line of questioning deliberately, laying groundwork for an alternative theory: a young woman, emotionally erratic, allegedly threatening to destroy a man's career, possibly harming herself. The prosecution will respond with common sense. Who stabs herself, then dismembers her own body? But the medical examiner's uncertainty is a crack, and the defense owns a crowbar.
Dr. Ho testified that he's willing to say she had been dead for weeks because there are weeks and months, but he couldn't say that she had been dead for months because there are no months and weeks. I know it's a little technical, but in other words, you have a witness who can't say certainly how long Celeste had been dead before her remains were discovered. So he cannot pinpoint the exact date of her death as April 23rd, 2025, based on the autopsy. And if the defense can convince the jury that she was alive past April 23rd, that's
third is the text weaponization.
to the 23rd, 2025. Again, this is the time period that we're talking about, the key moment when Celeste was allegedly killed. These were highlighted by the defense on cross-examination of Farrell. They arguably show that Celeste was demanding to see David before he traveled abroad, that she begged to see him in person, that he tells her no. This would defeat the narrative that he allegedly lured her to the property to kill her. And then Detective Farrell seemed to confirm that David says, okay, agrees to see Celeste on April 23rd, 2025. And after she sends him this text, cut this S out, I'm seeing you today. Now, Blair Burke, David's attorney, reads this allegedly threatening text from Celeste that was dated April 22nd, allegedly telling David that she will end his career and tell her father, quote, so many lies about him, that she's going to mutilate his quote, I will tell my dad so many bleeping lies about you, dead ass. I will end your career and your life. I will damage anything. She allegedly sent this on April 22nd. Now, Burke apparently also read a text from Celeste explicitly threatening to make anonymous accusations and, quote, leak all that S I got on you. And this is apparently in reference to whether or not David was going to post on Asia Collins' social media accounts showing the two of them together. There seemed to be an insinuation that she was jealous of this person. Asia Collins is somebody who we've talked about before, apparently in David's orbit. And Celeste apparently told David she has his contact information, his mother's number, threatening to release all this information. And then you have texts like this where Celeste allegedly wrote to David in August of 2024, I care about you. I killed my kid for you. I don't like talking about it because it gets me really upset, but I do anything to have it back. So why does this matter? Why is this all important? Well, here's the point. Yes, the prosecution can point to messages like that to say, yeah, she was threatening to expose him and ruin his career. He had a motive to kill her. So to protect his career, he lured her over and he killed her.
The defense introduced messages from Celeste to David that read less like victim communication and more like a pressure campaign. I will end your career and your life. I will tell my dad so many bleeping lies about you. Those words, dated April 22, 2025, reframe the narrative. The prosecution says David lured her to kill a witness and protect a $19 million record deal. The defense says she demanded to see him, threatened professional annihilation, and arrived as the aggressor. Both sides can use the same texts. The difference is which story fills the evidentiary void. The missing blade cuts both ways.
Highlight a few things that came out in the preliminary hearing, because the prosecutors claim that at 10:31, so the night that she comes over, the night that they claim he killed her, he sends this alibi text. Uber said, you're here. WYA. Where you at, right? Hello, bro. All these texts. And Detective Farrell testified that the texts from David to Celeste continue that night, that there's around a dozen texts from David to Celeste after her Uber arrival, after she arrives at the home. This is the allegation. Again, all about David purportedly confused about her silence. And Farrell testified that there was no additional activity from Celeste's phone after she arrived. Why? The allegation would be because she's dead. And Farrell testified that David's Tesla, the phone, left the Hollywood Hills residence around 11:30 p.m. to make these purported Santa Barbara trips, right? Farrell says the defendant's last text message to Celeste to her phone was April 26, 2025. So this was the day after his album Withered was released. So you have two things, right? You have no more activity from Celeste's phone. David never texts her again. They would argue suspicious. They would say he really has nothing to do with this and he just never contacts her again.
The fourth gap is the murder weapon itself. It's phantom. No knife, no sharp object has been recovered. Law enforcement searched the property. They cataloged chainsaws, an electric saw, cleaning supplies, a mop system, cadaver bags. But the tool that caused the penetrating wounds is not in evidence. Without it, the prosecution cannot physically link David's hand to the fatal act. They can show proximity, motive, opportunity. They cannot show the instrument. That is not fatal to a circumstantial case, but it opens the door to reasonable alternatives. Fifth, and perhaps most visually strange, is the dismemberment tool mystery.
Of an alleged murder weapon. What exactly did David allegedly use to dismember Celeste? Because prosecutors allege that David ordered 3 chainsaws to this home, but the 2 that were found in the garage in this residence didn't test positive for blood or DNA. Same for an electric saw that was found. There was testimony suggesting that a criminalist posited that if the blades had been used for human dismemberment, they wouldn't have been able to be cleaned to a point where their testing would have resulted in a negative result. And what I'll note about that is the deputy ME, Dr. Ho, testified that certain dismemberment is potentially consistent with chainsaw cuts. So what's the disconnect here? Well, one of the things prosecutors talked about was this third missing chainsaw. And they presented product photos of this Makita brand 10-inch chainsaw, apparently from Home Depot, apparently delivered by Postmates, but detectives confirmed that the chainsaw wasn't at the place. As far as we can tell, they don't have it. I mean, is this the one? Is this the one that he allegedly used to dismember Celeste? Because if you don't have the tool, that's a gap. Now, I asked private investigator Steve Fisher about this after the preliminary hearing. He was actually in that preliminary hearing for a bit of it. He had been following the case from the very beginning. Here's what he said about the chainsaw.
Well, the medical examiner said, because of the state of decomp, they can't say for certain exactly like how long of a blade or sharp instrument that was or whatnot. And listen, I think everybody assumes it was probably a knife, but there was a lot of time that passed in between. So it's mind-boggling to me that there was any evidence such as pool or anything still in that garage. I mean, the stupidity, right? If you're trying to cover this up. And part of me wonders, if he just knew he was going to get caught and was just kind of waiting. Because this was
Do you think the missing chainsaw is the key?
Yeah, I think that chainsaw might be in Santa Barbara.
The state introduced records showing David ordered 3 chainsaws to his home. 2 were found in the garage. Both tested negative for blood, DNA, human tissue. A criminalist testified that if those blades had been used to dismember a body, they could not have been cleaned to the point of a negative result. The third chainsaw, a Makita 10-inch model delivered by Postmates, is missing. Detectives confirmed it was not at the residence. Prosecutors implied that this third saw is the one. They presented product photos, delivery receipts, a glaring absence. But they do not have the saw. If the tool cannot be produced, the link between the purchase and the dismemberment stays circumstantial. The missing blade cuts both ways. Sixth is the identity gap behind the wheel.
Through that area, the roads that go off of it, there's some to go to a Boy Scout camp and stuff like that, but they're not well-traveled roads. So I don't know how he even knew about this place in the middle of the night.
And I asked DA Nathan Hawkman about the missing chainsaw too, and since this is an ongoing case, he really wouldn't give me much about it. But my personal opinion is, if they had the chainsaw, wouldn't they have presented it during the preliminary hearing, right? If they did, and they could show it was used in the dismemberment, they would have presented it. Particularly if they find a chainsaw in Santa Barbara where David is accused of going to, and maybe they could find something between now and trial. Maybe they could find this alleged murder weapon. Maybe they could find the chainsaw. I don't know. But when you talk about gaps...
David's Tesla traveled to Santa Barbara County in the dead of night, multiple trips according to digital data. Celeste's passport card was later found in that remote area. The inference is obvious: disposal of remains and evidence. Yet no witness has identified David as the driver. No surveillance footage captures his face behind the windshield. Could someone else have been using his car, his phone? The defense has not yet argued third-party involvement in detail, but the absence of positive identification leaves a silhouette where the state needs a person. A juror who wonders who else could have been driving is a juror who is not certain. Seventh is the silence of the inner circle.
We didn't hear any witnesses, eyewitnesses definitively saying it was David driving the car to Santa Barbara. Could someone else have used his phone? Could someone else have been using his car? I think another gap is just the lack of witnesses to what they saw and heard. I go back to the prosecution.
The prosecution's pretrial filings allege that David lied to friends about the smell of decomposition in his home, but at the preliminary hearing, none of those friends testified. Asia Collins did not appear. Neo Langston, who was reportedly arrested as a material witness and brought back to Los Angeles to testify before a grand jury, was not called. The state says this is normal. A preliminary hearing requires only probable cause, not the full case. DA Hawkman reiterated that what was shown was a small fraction. But we must note what we did not hear: no testimony that David confessed, expressed intent to kill, or described a plan. No message to a third party saying he feared her or needed her silenced. No admission, no boast, no slip. The prosecution will likely argue that this silence itself is evidence of consciousness of guilt. The killer who tells no one. But a defense attorney will stand before a jury and say the absence of words is not the presence of murder.
Prosecution's filing, prosecutors alleged that David lied to friends and associates about the alleged smell of decomposition at his home, at his residence. But I don't recall anyone testifying to that. We didn't see Asia Collins. We didn't see Neo Langston testify, purported friends, associates of David. I mean, you go back on July 4th, 2025, according to TMZ, there was a live stream that apparently showed David telling his friends, Neo Langston and Usgana, about this smell in his house, saying he apologized for how his bathroom smells, claimed that he went to the bathroom 2 hours earlier. Is that going to be presented by the prosecution to say he's lying about what the smell was? So a gap for me is, what would they testify to? If you recall, Neo was reportedly arrested for failure to appear as a witness and was seemingly brought back to LA to testify before a grand jury. We know there was an effort to subpoena David's family members too to testify. None of that happened at this preliminary hearing. Gaps. What would they testify to? Would they testify about the purported illegal sexual relationship between David and Celeste? Would they testify about the Tesla? I don't know. But again, the prosecution is under no obligation to present everything they have at a prelim. Remember, Hawkman said a small fraction of evidence. And when you think about what those in his orbit, David's orbit, could testify to, one of the potential deficits in this case is that I don't recall any testimony yet that David texted or communicated with anyone about an intent to kill Celeste, or that he was afraid of her, or that...
And now we arrive at the question that turns this case into something more than a legal puzzle. If the state cannot prove the time of death, cannot locate the murder weapon, cannot recover the dismemberment tool, and cannot produce a single eyewitness to the act, then what precisely is the murder charge built upon? The answer is pattern, timing, and the grave insult of a child's body concealed in a Tesla. That is powerful. That is disturbing. But here is the ticking clock. Every day that passes without hard evidence, the prosecution's window of certainty narrows. This is not a thriller about what happened. It is a thriller about whether 12 strangers will agree on a version of events that no camera captured and no confession confirms. And that should terrify anyone who believes the justice system runs on proof, not presumption. The moral refrain of this case, the phrase that the defense will hammer until the wood splinters, is the one that already echoes through the preliminary hearing transcript. The evidence of death is everywhere, but the evidence of murder is circumstantial. The state's burden is not to show that David Burke had the opportunity to kill, or the means, or even the motive. It is to exclude every reasonable hypothesis of innocence. And right now, those hypotheses have names: self-harm, third-party access, timeline uncertainty, missing tools. None may be likely. None need to be likely. They only need to be reasonable. DA Hawkman told News Nation that this will be a strong circumstantial evidence case.
It shows a young woman's body was transported and concealed. And while this circumstantial evidence supports concealment of a death, it doesn't support a killing or the requisite intent, forethought that would make it first-degree murder, that the law recognizes two forms of malice. And her argument was neither. And then if you don't have either, there's no murder. Express malice was a deliberate intention to take away a life, and she argued there was no evidence showing deliberate intention here from David. She argued there's no statement of intent anywhere to harm her. There was no history of violence or hostility from him to her. How the relationship, the evidence listed here is the opposite.
And he is right to say such cases are won routinely. Circumstantial evidence can be as powerful as direct evidence. But the flip side is that every gap is a door, and the defense only needs to open one. The next critical moment will be the arraignment on August 31st, where the formal reading of charges will occur and the trajectory toward trial will harden. Between now and then, investigators may find the missing chainsaw. They may uncover a witness who heard something. They may locate the murder weapon, or they may not. And if they do not, this case will be decided entirely on whether the small but illustrative fraction is enough. Our final instruction to you is to act as your own investigator. Go to the publicly available transcript of Detective Corey Fell's testimony from the preliminary hearing filed in Los Angeles County Superior Court. Search for the line where he confirms no surveillance video captured the events of April 23. Read it. Then come back to the comments of this video and answer one question. Does the state's inability to show you the killing make the mosaic of inferences stronger, or does it leave a hole too large to ignore? Because that is precisely the question 12 jurors will have to answer, and their answer will be the difference between a conviction and a reasonable doubt that could change everything. If this forensic breakdown brought you clarity, press like, share it with someone who follows true crime, and subscribe to Endless Crime with notifications on. We don't sensationalize, we follow the evidence.